The broadcast is now starting. All attendees are in.
Hello, my name is John P.L.L.C. I'm a probate litigation attorney or an estate trial lawyer with the West Palm Beach, Florida law office of the P.L.L.C. Hauser law firm, P.L.L.C. Hauser in downtown West Palm Beach, Florida, on the web at phflorida.com. P as in P.L.L.C., H as in Hauser, Florida.com. Thank you for joining us for a live webinar on Will Contests 101. I'll be your host throughout today. My name is John P.L.L.C., and I'm going to be speaking to you in a very concise, fast-paced manner for about 35 to 40 minutes, intended to be an introduction to will contests, primarily in Florida, but many of the concepts are most probably applicable wherever you're listening from. I'm going to be discussing 6 specific topics, and after the introduction and background, I will conclude. You'll have an opportunity to ask questions, which will be entertained at the end of the webinar by addressing your questions on the screen in front of you. So let me give you a little background. We'll go into an introduction, and we'll get into our 6 topics right away. My firm limits its practice to estate, probate, guardianship, trust, and commercial litigation trials and appeals throughout Florida, but we are based in West Palm Beach, Florida. My partner, Rob Hauser, has a background in appeals. He's Florida Bar Board certified in appellate law, as well as extensive experience in commercial litigation and trials. I have a background in wills, trusts, and estates, and our practice is focused and limited. So let's begin and let's start talking about what we're going to be doing today. The discussion topics that I'll be speaking about are the following. First, we're going to talk about 3 ways to set aside a will, 10 things probate judges want to hear in a will contest trial, defending a will contest, the X factor, what I call the X factor of challenging a will, 10 things you need to know before contesting a will, and how to pick a lawyer for your will contest. Why does this all matter? Well, the Boston College Center of Wealth and Philanthropy tells us that $56 trillion are passing from the World War II generation to the baby boomers and now the millennials, Gen X and Y, and the greatest transfer of wealth in the history of humankind. Much of that wealth is ending up in estates or will substitutes like bank accounts, IRAs, even annuities, beneficiary designation forms, trusts, and wills. And many people are litigating that. Many people are contesting it. Everybody seems to have a second or third spouse, 2 or more families, children from prior relationships. And everybody seems to have a say on whether they should inherit something or not. So we're going to look at 3 ways to set aside a will. And what we're going to be talking about today is what some people or probate litigators might call contesting a will, objecting to probate, filing a petition to revoke probate, challenging a will. All these terms seem to be used by the general public to describe trying to contest what a will that's been filed with a court says. And the background we're going to use is that a will has been filed or submitted to probate, and somebody has been disinherited. They received no inheritance under the will, or perhaps they received less than a prior will. And so they file a will contest, or they file a challenge to the probate, or they file a challenge to the will and they want to overturn it. Now, this webinar today is intended for the general public, although I think paralegals and lawyers will find it helpful, and I hope they find it insightful. But nonetheless, our future webinars will feature 50-minute sessions, which will be eligible for CLE, or continuing legal education credit, particularly in the ethical field. So let's begin this right now and get into the 3 ways to set aside a will. So many of the relatives that are out there when someone passes away are counting the money in the limo on the way to the funeral. For good or for ill, that's happening. many children, and not minor children, but adult children, have a misconceived notion that they're actually entitled to an inheritance. And so one way to set aside a will is if the will was not signed right, if it wasn't executed properly. There are certain legal formalities that are required when signing a document, which also requires witnesses. If that wasn't done properly, the will can be set aside and declared invalid. What's the second way that a will can be set aside? Well, everybody knows that you have to be competent to sign a will, right? You need to know what's going on. But if somebody is incapacitated or is incompetent or lacks capacity, did not know what they were doing when they signed a will, did not know the nature and extent of their assets and their estate and their property or who their relatives are, that will can be set aside. So many times you'll hear people talk about, well, mom or dad was suffering from dementia and Alzheimer's, and look, there's varying degrees of that, and it can be regulated or perhaps not regulated depending on any number of medications and if the dosage is right or not. But if somebody didn't understand what they were doing, you can set aside a will. What's the third way that a will can be set aside? Well, the third way that a will can be set aside, if it was obtained wrong, or what probate litigators call being procured improperly or procured incorrectly or just plain old wrong. And the most common accusation or allegation about an improperly procured will is undue influence, right? When somebody, through force, persuasion, coercion, does something to force somebody, coerce, convince somebody to sign a will to leave them an inheritance or to disinherit somebody else, that part of the will or that entire will may be set aside. So those are the three ways that you can set aside a will. So let's go to the next step now, and let's talk about a will contest trial. What do probate judges want to hear in a will contest trial, right? Let's talk about some trial procedures, some rules, and perhaps some techniques to victory, right? What are 10 things that probate judges want to hear when there's a will contest? Well, first of all, they want to hear from the drafting attorney. Who's the attorney that prepared the will? Who wrote the will, right? What do they have to say? Did they meet with the client who signed the will? Who paid for that will? Who retained the attorney? Who was present when that will was signed, right? Does the drafting attorney have personal knowledge of the person who signed the will? Were they a long-time drafting attorney, a will and trust attorney who wrote wills or trusts or estate plans for this client over a number of years? Or is that drafting attorney someone who was just hired by the person who brought mother or father in to sign the will? What does the drafting attorney say? Very, very important, highly important. What else does a probate judge want to hear, or who do they want to hear from? They want to hear from the witnesses. In Florida, for a will to be valid, you need the person who made the will or signed the will to sign it at the end of the document, and you need to have two witnesses. And the two witnesses need to sign the document in the presence of the person who signed the will, and that person has to sign it in the presence of the two witnesses. That's what we call the execution ceremony. And so what do the witnesses say? Did the witnesses know the person who signed the will? What did they observe? Did they observe that the person who signed the will was alert, oriented, knew what they were doing? Was there a communication? Were they talking? Were there any discussions or admissions that this is what they were doing, that they were signing a will? Or was there silence? Did somebody need a hand signing the will? Was anyone else present? You want to speak to those witnesses and find out just what the heck went on when that will was signed. So you have the drafting attorney, the person who prepared the will, and many times it's an attorney, but you also want to speak with the witnesses. Well, the third thing that probate judges want to hear or see are the doctors and medical records, right? If there's a lack of capacity allegation, if there's an allegation that says, I don't think Dad was competent when he signed the will and disinherited me. Well, what was Dad's medical condition at the time? What was his mental condition like at the time he signed the will? And of course, what's relevant is the time immediately before that and immediately after that. So what do the doctor's records say? Did Dad see an attending physician regularly? What do those medical records say? What would that doctor testify to? What about A neurologist. Was Dad seeing a neurologist? Was he suffering from dementia or Alzheimer's? Was he taking medication? What was the dosage of the medication? How did the medication interact with Dad, right? Was the dosage too high or too low? Was it adequate? What do the medical records say about that? What about visiting nurses, other physicians, other doctors, nurses' aides, anybody who provided medical care to Dad at or around the time of signing the will seems to be relevant to the issue of whether Dad had mental capacity at the time he signed the will. What's number 4? Well, judges may want to hear from friends and neighbors, right? Probate trial lawyers, when they are participating in a will contest case, need to know, in our example, if Dad signed the will, who Dad was talking to, who Dad socialized with at the time of signing the will. Were there friends that he regularly golfed with or played tennis with? Who were his neighbors? Was there interaction? Did he play bridge with somebody on a regular basis? Who were his best friends? If Dad lived in an assisted living facility or a nursing home or a facility that provided greater care, what did people on the floor say? His neighbors, people he ate with, the attending nurses and doctors. What did they all say, right? Judges in a will contest case want to hear about that. Why? Because the interaction between those friends and neighbors are very important, right? From that, a court can draw an inference whether Dad was with it or not. Are there any prior wills that Dad had, and what do those say? Does a prior will leave something to somebody who has filed the will contest, or to somebody who's inherited, right? What does the present will say? If it disinherits me and cuts me out, is there a prior will that reinstates me? Is there a prior will that leaves me an inheritance? Estate trial lawyers will tell you that that's very significant on the issue of standing, whether somebody has a legal ability to come into a probate court and participate in a probate proceeding, let alone a will contest. But estate lawyers will also tell you that the doctrine of dependent relative revocation is very, very important. And what that means is there's, in many states, including Florida, there's an assumption that Dad did not want to die without a will or die intestate. And if pled properly, the doctrine of dependent relative revocation will revive prior wills. Number 6, circumstantial evidence. You know, many times people who call up and say, hey, I have a will contest, so-and-so exerted undue influence over Dad, but I live in California and Dad's in Florida and I didn't see it. I wasn't there. I was working. And I didn't see it, so I know I don't have a case. And that's not necessarily so, right? You don't have to be there to prove an undue influence case necessarily, right? Undue influence cases can be based on circumstantial evidence, right? As long as you have competent substantial evidence from which a trial judge, a probate judge, can draw a reasonable inference and a reasonable conclusion, that may be just fine. So don't think that you don't have a case to contest a will just because you weren't there. What do you need? Well, you do need credible testimony, right? A judge is going to be looking at your witnesses that you call. He or she is going to be evaluating their credibility and determine whether they're telling the truth or they're lying. You need good, credible witnesses, good, solid, credible testimony. Is what the witness testifying to accurate? Is it correct? Does it sound right? Is the witness's memory sharp? Does the witness recall everything clearly, or is the witness speculating? Trial lawyers know that speculative evidence or speculative testimony and hearsay are inadmissible. So your witnesses better be credible. Reasonable inferences. Judges every day draw reasonable inferences from the evidence that's presented. So you need to know what inferences your probate judge should be drawing, or what inferences you want the judge to draw. You need to connect the dots and present your case to the court, right? Most likely it's a bench trial, a trial in front of a judge rather than a jury. Although a tortious interference case with an inheritance, you can get a jury on that. That's an element of fraud. You can get a jury case on most fraud cases or torts. certainly in Florida. But what are the reasonable inferences that a judge can draw or a court can draw from the evidence that you're presenting? The ninth thing that a probate court wants to hear is the law on your side. If you have a case that's very supportive of your position, you need to fly that flag. You need to know those cases cold, and you need to cite them and recite them over and over again. What does the law say? Do you have an uphill battle? Is the law on your side? If it's not, you better have a plan B. And finally, just the facts. At the end of the day, you need to have good facts, and you need to be able to tell your story and have your witnesses testify with a straight face. It's got to pass the smell test, right? So some law firms use focus groups or mock jury trials to run the facts by them. And if they're just not buying it, if they just believe that your facts or your case seems too far-fetched, you need to go to a plan B. Okay, let's talk briefly about defending a will contest, right? Let's say that a will contest has been filed. A will was filed with the court. In Florida, the custodian or the person who possesses the last will needs to file it within 10 days of the date of death, and you file it with the clerk of the courts of the county where the person who made the will passed away. So let's assume that a will was filed, and let's assume that it leaves you an inheritance. Let's say that you get 10% of the estate. And somebody has filed a will contest. Somebody filed a petition to revoke probate and a petition to have the will that's been filed set aside. The question that you might want to think about is, should you as a beneficiary get involved to protect your inheritance, right? If you're a beneficiary, if you receive 10% of the estate, you might be sitting back and saying, well, you know what? There's this person who's running the estate called the executor, or in Florida, the personal representative, and they're defending the lawsuit. They've got lawyers, and they know what they're doing. I'll just let them carry the ball, and I'll put my 10% inheritance in their hands. Well, you can certainly do that if you have confidence in them, but if you want to get involved or you don't have confidence in them, as an interested person in the estate, you, a beneficiary, you have the ability to participate in that litigation, and you can get involved in an attempt to try to protect your inheritance and thwart the will contest case. Let's talk about the X factor of challenging a will. This is a term that I've phrased over the past few years as I've spoken and written about probate litigation and related topics, right? What is the X factor when challenging a will? Well, the X factor is attorney's fees. Why do I say that? Well, if you're defending a will contest case, you've got to pay lawyers to defend that case, and lawyers are expensive, particularly with trial work. If you are filing a will contest case, how are you going to get a lawyer if you can't afford one, right? You need to understand that litigating these matters is expensive. In addition to that, you should know that in Florida there are fee-shifting statutes, right? And other states have them as well, where if you lose, you may end up paying the other side's or the winning side's attorney's fees. And many times these probate litigation cases are so time-consuming and so expensive that attorney's fees really becomes an X factor, right? You don't want to spend $100,000 necessarily on legal fees for a probate trial or a will contest trial, fighting over $50,000. That doesn't seem to make financial sense. You should also be mindful that the losing party may have to pay the other side's attorney's fees at the end of the trial. So if you're defending a will contest case, you should, or your probate litigation team should know how to try to seek attorney's fees from the other side. And by the same token, if you're filing a will contest case, if you prevail, you should recognize what opportunities you may have to be reimbursed your attorney's fees from the estate. You should also be mindful that if you lose your will contest case, you may have to pay the other side's attorney's fees, or you might lose your inheritance, right? There's will contest cases where people are disinherited, and they say, I want to overturn the will because I didn't get any inheritance, right? That's one set of facts. The rules for whether you're responsible for paying attorney's fees to the other side if you lose, the rules for that are one set of rules. And the other side of that coin is if you do get an inheritance under the will, let's say you get 10%, but you're still contesting the will. Why? Because you think that you got cut down from 100% to 10%, 100% from a prior will to 10% to the present will, and you think the will was the product of undue influence. And so you're filing a will contest to overturn that will where you get 10% because you want the prior will to govern. You want 100% of the estate. Well, you need to be mindful that if you lose your will contest case under Florida probate code, Florida probate law, you could lose your 10% inheritance in the way of attorney's fees. Now, if you don't get an inheritance, right, there's cases out there in the statute that suggest that you're not responsible, personally liable for attorney's fees. But there are other ways that you can be assessed attorney's fees. So let's move on to the next topic, which is 10 things you need to know before you contest a will. What does your best day in court look like, right? Before you file your will contest case, one of the things that you want to consider is what you're fighting over. What's your best day in court look like, right? Many times these will contest cases are all in or all out. They're all or nothing, right? Thumbs up or thumbs down. The will's either valid or not valid, right? Many times will contests involve people who got disinherited. They received nothing under the will. You know, one of the most common examples is, let's say, there's a son, and the son gets nothing under the will. And the son says, that's not right. I've read the will, and the will says all to my caregiver, or all to my neighbor, or all to my postman. And the son says, that's just wrong. There's no way that mom or dad did that, right? And so you don't know of any other prior wills, so you think that will is invalid, in which case your mom or dad died intestate without a will, in which case the estate of your mom and dad would descend to heirs at law by intestacy, the laws of intestacy, and as the only son, you would inherit everything. What's your best day in court look like? Well, it's all or nothing for you, right? If the will is valid, you get nothing. If the will is invalid, you get everything. So you better know what you're fighting over and what your best day in court looks like. And you should also consider what your attorney's fees will be, whether you can get attorney's fees from the other side if you prevail, and likewise, if you don't win your case, whether you have to pay the other side their attorney's fees. And there's different rules for that, right? The rules differ based on whether you get an inheritance or not. And by the same token, you need to look at that other side of the other side of that legal coin, right? You need to look at the worst day in court. What happens if you lose on everything? Well, if you lose on everything, you might lose your inheritance if you were named as a beneficiary under the will that you're contesting, and you might lose your inheritance because you have to pay the prevailing side's attorney's fees, right? Or if you've engaged in baseless litigation, bad faith litigation, you might be sanctioned by the court even if you don't get an inheritance. Right? There's cases in Florida, for example, like the Bitterman case, and there's statutes in Florida like 57.105 that sanctions bad faith litigation. When you bring a claim where there's no basis in fact or in law, you and sometimes your lawyer can be sanctioned for this litigation by paying the other side's attorney's fees, even if you don't receive an inheritance. How much discovery do you need, right? Discovery is the process by which you're learning the facts. You've got to find out what mom or dad was doing when they signed that will. You've got to find out what was going on around that time. How was the will procured? Who paid for that will? You may have more questions about mom or dad's other assets or property. Were there transfers with the power of attorney just prior to death? Were there large checks written to somebody just prior to death? Were there changes to the bank accounts just prior to death, or the change of a beneficiary? Why does that all matter? Well, all those assets may or may not go into the estate if there was undue influence. 4, how much are you fighting over, right? At the end of the day, it doesn't make sense if you're spending $100,000 in legal fees fighting over $50,000. So you should get an idea of what you're fighting over, right? It should make financial sense for you because there is risk with litigation, right? Even when you have very good cases, great facts, and good law, there's no guarantee that you're going to prevail. So you should assess with your probate litigation team what your risk factor is. What's your best day in court look like? What's your worst day in court look like? And what's your risk factor? And you should assess that risk factor and assign it some type of a value so you know what you're fighting over. 5, does mediation make sense? Can you go to a conference where a third party, a neutral, objective person, such as a retired judge or a probate litigation lawyer from Florida who's not involved in the case, will act as a mediator in an attempt to facilitate discussions, analyze the law, discuss the facts in an attempt to resolve one or more issues or maybe your entire will contest? How good are the facts, right? You really have to know that. Can you replace? How are the facts going to be accepted by the judge or the jury, right? Do you think your facts are very, very strong? Are they very good? Or are they very, very bad? You need to be upfront with yourself, and your client when you're analyzing this. If your facts aren't good, you have to face that reality. And you need to maybe focus on the law, or you maybe need to think about settling or going to a plan B. If the facts are very, very good, that's good. How are you going to use that to push your legal case forward? And by the same token, don't think that there's zero risk factor. Even with really good facts, there's still a possibility, right, that you could not prevail. So you need to know those facts and be realistic about your possible outcomes and expectations. What are the other side's best defenses, right? Many times younger lawyers will focus on their case, their case, their case. But dear God, you've got to place a lot of attention on the other side, and don't discount the other side's arguments or facts, right? The other side, you may believe, has terrible evidence, poor witnesses, non-credible witnesses, bad documents. The other side may not have as good a trial lawyer as you do. But don't discount it. Why? Because there may be a witness or evidence or something that the judge or the jury is stumbling upon that is important to them, that they think is important, and which, quite frankly, you may not think is as important, right? That would be a terrible mistake. So don't discount the other side's defenses. What are the other side's best defenses? You need to know what they are. You need to know how to combat them, and you better have an answer for them. You need to know a way to address them and try to get around them. Number 8, what's your evidence? Who's your first witness? Who do you call? Who do you lead with? How credible is that testimony? Are your witnesses great? What documents do you have? What do the medical records show? What do the financial records show? Did somebody who unduly influenced mom or dad to sign the will, did they also engage in a pattern of conversion or civil theft? Were they at the same time changed to IRAs and annuities and bank accounts? Were they writing checks themselves or perhaps misusing the power of attorney? All of that evidence can be important to demonstrate what was going on around the time that mom or dad had signed a will. And by the same token, if you're on the defense side, what's your evidence to demonstrate that mom or dad knew what was going on? Were they watching CNBC and buying and selling stocks? Were they selling real property? Were they talking to their neighbors and friends and planning their retirement, making trips, or were they out of it? Who do you call as your first witness, right? What documents can you get into evidence? Number 9, can you make the other side pay your attorney's fees? God, we've talked a lot about that today, including as the X factor. That's a very important consideration in any will contest case. And then what about an appeal, right? You need to be prepared for an appeal. Are you framing the issues if you lose? Have you anticipated the issues if you prevail in the other side appeals? Do you have an appellate lawyer at your trial to attempt to recognize, plan for, and prepare for a possible appeal to your will contest case? Now, let's move into the last topic before we conclude, and let's spend a few minutes talking about how to pick a lawyer or how to try to choose an attorney for your will contest case. 5 things you may need to know or want to consider. The first one is experience, right? How many years has your lawyer been doing this? Is your lawyer fresh out of law school with very little trial experience? Or is your lawyer somebody who's had a number of trials and evidentiary hearings, a number of fee hearings, a number of hearings and evidentiary trials involving undue influence, lack of capacity? Has your lawyer issued dozens and hundreds of subpoenas and reviewed thousands and thousands of pages of medical records or financial statements so that they know what they're looking for, right? Years and gray hair perhaps do matter when you're on the 9th or 10th floor of the courthouse ready to make your case in a will contest matter. Or when you're in courtroom 4B in the main courthouse of West Palm Beach. Number 2, trial experience, right? Don't you want somebody who knows Chapter 90, the Florida Evidence Code? Don't you want them to know about attorney? Shouldn't they know about hearsay and what a witness can testify to or should be prohibited from testifying to? Exclusionary principles of evidence. Shouldn't you also know how to keep certain evidence from coming in or certain facts in as evidence? Do you know what objections to make and when to make them? Do you know the proper procedure for handling a trial, both pre-trial matters and post-trial matters? Do you know how to handle an attorney fee hearing, which in essence is a trial? Right? Trial experience, years and years of being in the courtroom, handling high profile, large dollar, big, important cases is often very important when you're trying to choose who's going to handle your probate litigation and who's going to be part of your estate litigation team. Why? Well, if your mom passes and you have a will contest involving mom's estate, you only have one mom, right? So that's only going to happen once. You're only going to have one will contest. So you should perhaps focus on who is going to be part of your estate litigation team. And while we're talking about focus, one consideration is whether you want your estate lawyer to be a focused or a limited lawyer. And what I mean by that is, do you want a criminal lawyer handling your will contest case? Probably not. Do you want a divorce attorney handling your will contest case? Most probably not. You do want somebody who's handled will contests before, ideally, right? And many times there are boutique firms that are small or medium-sized firms who limit or restrict their practice just to probate litigation. And here in South Florida and throughout Palm Beach County, there is a handful of very good probate litigators, very good estate firms who have probate litigators on their staff who do a very, very good job, are very focused and concentrated in their law, right? And that's all they handle. Probate, estate, guardianship-related trust, perhaps maybe some corporate matters and appeals. Number 4, what about respect? Does your probate litigation attorney limit his or her practice to this area, and are they respected? When they walk in that courtroom, is your lawyer getting the respect of the judge, the court, and his or her peers? Does that even matter to you? Well, it may not matter to you. But if it does, certainly respect is certainly one key to consider. Is your estate lawyer being asked to mediate complex high-dollar matters? Is your probate lawyer being asked to handle an appeal? Is your probate or estate attorney being asked to mediate, act as a mediator to resolve complex estate or trust disputes? And finally, is your lawyer being hired by other attorneys? Probably the last issue that you may or may not want to consider when choosing a probate litigator is, how serious are your lawyers? Try to get a lawyer who matches up with you, right? Who matches up with your personality and your approach to the case, right? Generally speaking, most people, I think, want their lawyers to be serious attorneys. Are you focused and furious? Are you aggressive but civil? Are you unapologetically strong, right? Don't you want your attorney to be move things forward, not have a case languish for a long time and years in probate court? Don't you want to make progress and not excuses? So those are some factors that you can consider in determining how you're going to choose your estate litigation attorney and whether you want them to focus on that particular area. We're moving now to conclude So before testing a will, remember that it's important to consider certain things, right? In what ways can you set aside a will? We discussed the 3 ways at the beginning of the program. Is it an undue influence case, a lack of testamentary capacity case? Is it a little bit of both? Or do you believe it wasn't signed with the requisite qualities? Each of them carry different burdens, although they're very related. You need to understand each of them and the approach to your will contest style and case. What would the probate court judge want to hear my will contest case? Right? Very, very important. What are you going to prove? How are you going to say it? Will it be received well by the probate court? How can I defend a will if I have an inheritance under the will and the will is to get involved, or do I let somebody else carry that burden and hope for the best? What should I know before contesting a will, right? What are some of the factors I should consider? And how do I evaluate my case? What does my best and worst day in court look like? What's my risk factor, right? Because there's always a risk factor of possibly losing. And how do I assess that or assess that with a value, right? How can I evaluate what my prevailing are, my odds of losing, and what I'm fighting over? And finally, what factors might I want to consider when I'm hiring a probate litigator or an attorney? I want to thank everybody for listening. I appreciate everyone's attendance. My name is John P.L.C. from the West Palm Beach law firm P.L.C. Hauser, phflorida.com. I look forward to spending more time with you in the future and bringing you future webinars on litigation and appellate topics involving wills, trusts, estates, and related guardianship matters. Thank you for listening.